You are on bond for a terroristic threat, and now you've picked up a new case. You now stand charged with the offense of driving while intoxicated. First offense, it's over a .15, so you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On January 24th, 2025, the officer was dispatched to a vehicle accident on Conklin Lane, Harris County, Texas. The officer observed the defendant's vehicle stuck in grass, and the officer made contact with the defendant, the driver, and sole occupant. The defendant stated he was going fast and lost control because he hydroplaned. However, the officer observed no water or ice on the road. The officer observed glossy eyes in the defendant's one eye, slurred speech, and a strong odor of an alcoholic beverage. The defendant stated he was on his way home from NRG as he was at a rodeo event. The defendant stated he drank 2 beers and standard field sobriety tests were administered, HGN 3 out of 6, and the walking turn was unable to be performed due to equilibrium being off from the defendant only have one eye. The one-leg stand was started, but the defendant stated he could not do the test 20 seconds as the test had already been started. The defendant read the DIC and consented a breath. The results were .161 and .155.
All right, Mr. Proctor, I'm going to find that there's probable cause to go forward with a new case. We have not addressed the old case, correct, Mr. Pons?
No, sir.
Okay. Because you're on bond, you picked up a new case. I'm now revoking your bond on the first case. Goes with you. The bond is set at $5,000 now, James. I usually, when it's, yeah, you raise it up to 5,001 now because it's 5,000. I guess I'll do half and I'll do it 7,501.
Okay. I was hoping maybe on the probable cause issue first.
Oh, tell me if you have an argument. I'm all.
Well, it's got one eye, so the tests are off. So all you have is him just saying I had 2 beers as probable cause of intoxication.
But you know that's not. I mean, you take it as a totality. There's all the other.
Your Honor, respectively, they observed HGN in the one eye, the 3 out of 6, and that
I don't think you can do that.
Have the odor, and they still have his statement being that he drank 2 beers, and then also his refusal to do the test, and then as well as the
You have an accident
and the strong odor of an alcoholic beverage.
I mean, you have a
So
breath test it's twice over the legal limit as well, allegedly. So, I mean, I think that there's enough to go forward for probable cause purposes. Beyond a
Okay.
reasonable doubt, I don't know, but I think there's enough. It goes with you.
Well, he's got one eye, so I got to at least try.
I got it. I understand. And,
Okay.
and look, I wouldn't take credence in that test anyways, you know? I mean, even assuming it's done all correctly, what it's 77% chance as it is.
Gotcha.
Yeah, but taken together the totality of everything else, I think it's sufficient. So,
Okay. What about instead of revoking the bond? Because what we did last time with Judge Andrews was she kept the bonds the same, and we let him out, hoping that the conditions on the DWI would satisfy any threat to the community.
no, I want him to get it. He's not getting it. And so,
Okay.
I mean, if he's unable to make bond, come back and we can talk. But not now.
Okay, so what was the new amounts now? Or the new amount?
7501 on the, I'll leave the DWI as is, but 7501 on the terroristic threat. He will pop up on tomorrow's docket, James. So,
I'll see you
yeah.
tomorrow. Okay, cool.
Okay.
All right,
See you.
thank you.
Take care, bud. Mr. Theron. Hey, bud. Great to see you, man. It's been too long. It's been too long. What's new?